Okay, so good morning, everyone. My name is Vincent Cotanda, and I will be discussing some articles on the law of obligations and contracts. So, Article 1323, an offer becomes ineffective upon the death, civil interdiction, insanity, or insolvency of either party before acceptance is conveyed. So, when other when offer becomes ineffective, so an offer may be revoked or withdrawn at any time before it is accepted merely by communicating such intentions to the other party. After acceptance, the contract is already perfected. So under Article 1323, even if the offer is not withdrawn, its acceptance will not produce a meeting of the minds in case the offer has already become ineffective because of the death, civil interdiction, insanity, or insolvency of either party before the conveyance of the acceptance of the offer. Always, to add more, it must be observed that the law refers to either party. These parties, offerer and offeree, must be living and, incapacitated. So, other grounds which render offer ineffective. So, the above grounds are not exclusive. Thus, failure to comply with the condition of the offer as to the time, place, and the manner of payment, the expiration of the period fixed in the offer for acceptance, the destruction of the thing due to due before acceptance, and rejection of the offer, etc., will also render the offer ineffective and prevent the creation of a contract. Next is Article 1324. When the offerer has allowed the offeree a certain period to accept, the offer may be withdrawn at any time before acceptance by communicating such withdrawal, except when the option is founded upon a consideration as something paid or promised. So, meaning of contract of option, option period, and option money. So when we talk about option contract, it is one giving a person for a consideration a certain period within which to accept the offer of the offerer. It is separate and distinct from the contract, which will be perfected upon the acceptance of the offerer. Option may also refer to the privileges itself given to the offeree to accept an offer within a certain period. Period. So when we talk about option period, it is the period given within which the offeree must accept the offer. However, option money is the money paid or promised to be paid in consideration for the option. It is not to be confused with earnest money, which is actually a partial payment of the purchase price and is considered as proof of the perfection of the contract. Now, withdrawal of the offerer where period stipulated for acceptance. When the offerer gives to the offeree a certain period within which to accept the offer, the general rule is that the offer may be withdrawn as a matter of right at any time before acceptance. The exception is when the option is founded upon a consideration as something paid or promised. Now, Article 1324 and 1479 compare. So, Article 1324 lays down the general rule regarding offer and acceptance. It has been interpreted as modified by the provisions of Article 1479 of the Civil Code, which applies specifically to a promise to buy or sell. A unilateral promise to buy or sell a determinate thing not supported by any consideration distinct from the price for which that thing was intended to be sold by or to the promisee does not bind the promiser, even if accepted. It may be withdrawn at any time. Example is, suppose the offerer of Paul is to buy the house of Peter, giving the latter 10 days within which to accept the offer. In this case, Paul may withdraw his offer at any time, even after acceptance by Peter. If Peter has not paid or promised to pay a consideration to Paul for giving Peter the 10-day period within which to make up his mind. Next is Article 1325. Unless it appears otherwise, business advertisements of things for sale are not definite offers, but mere invitations to make an offer. So business advertisements generally not define offers. Business advertisements of things for sale are not definite offers, acceptance for of which will perfect a contract, but are merely invitations to the reader to make an offer. However, if the advertisement is complete in all the particulars necessary in a contract, it may amount to a definite offer, which, if accepted, will produce a perfected contract. For example, for sale, 200 square meters lot of Green Plains Village, in Quezon City for 1 million pesos, uh, telephone number 8441284. So meaning this type of example, it is not a definite offer. Next is Article 1326. Advertisement for bidders are simply invitations to make proposals, and the advertiser is not bound to accept the highest or lowest bidder unless the contrary appears. So advertisement for bidders generally not definite offers. In advertisement for bidders, the advertiser is not the one making the offer. In reality, the bidder is the one making the offer which the advertiser is free to accept or reject. Acceptance by the advertiser of a given bid is necessary for a contract to exist between the advisor and the bidder, regardless of the terms and conditions of his bid. Okay, as a general rule, the advertiser is not bound to accept the highest bidder or the lowest bidder unless the contrary appears. In judicial sales, however, the sheriff or auctioneer is bound to accept the highest bid. Next is Article 1327. The following cannot give consent to a contract: unemancipated minors, number two, insane or demented persons, and deaf mutes who do not know how to write. So, capacity to give consent presumed. In the Civil Code does not define who have capacity or legal ability to give consent to a contract. It defines, on the contrary, who have no capacity, by which it can be inferred that capacity is the general rule, which exists in those of whom the law has not denied. The burden of proof is on the party who asserts incapacity. So next is persons who give consent. A contract entered into where one of the parties is incapable of giving consent to a contract is voidable. A voidable contract is valid and binding until it is annulled by a proper action in court, and it is susceptible of ratification. So those who are incapacitated to give consent under Article 1327, 1327 are the following. First is emancipated minors. So what are these? So they are referred to those persons who have not yet reached the age of majority or 18 years old and are still subject to parental authority. A minor can be emancipated by attainment of the age of majority, by marriage, or by concession recorded in the civil register of the father of or of the mother who exercises parental authority. Next is insane or demented persons. So insane or demented persons, these are the insanity must exist at the time of contracting, unless provided otherwise, a person is presumed sane, and deaf and mutes. So they are persons who are deaf and dumb. However, if the deaf mute knows how to write, the contract is valid, for then he is capable of giving intelligent consent. A person who does not know how to write does not know how to read, and one who knows how to read necessarily knows how to write. So a contract entered into by a deaf mute knows how to read is therefore valid, although he cannot write because of some physical reasons. Next is reason for disqualification. So the reason behind Article 1327 is that those persons mentioned can easily be the victims of fraud as they are not capable of understanding or knowing the nature or import of their actions. They can enter into a contract only through a parent or guardian. Next is Article 1328. Contracts entered into during a lucid interval are valid. Contracts agreed to in a state of drunkenness or during a hypnotic spell are voidable. So contracts entered into during a lucid interval. So lucid interval is a temporary period of sanity. A contract entered into by an insane or demented person during a lucid interval is valid. It must be shown, however, that there is a full return of the mind to sanity as to enable him to understand the contract he is entering into. So, effect on drunkenness and hypnotic spell. So, drunkenness is and hypnotic spell impair the capacity of a person to give intelligent consent. These conditions are equivalent to temporary insanity. Hence, the law considers a contract entered into in a state of drunkenness or during a hypnotic spell voidable, and it is not required that such state was procured without circumvention of other party. Next is Article 1329. The incapacity declared in Articles 1327 is subject to the modifications determined by law and is understood to be without prejudice to special disqualifications established in the laws. So, incapacity declared in Article 1327 subject to modifications. In general, the contracts entered into by the persons enumerated in Article 1327 are voidable. However, in certain cases, their incapacity may be modified by law. That is, they can also give valid consent. Thus, number one, when necessities such as food are sold and delivered to a minor or other person without capacity to act, he must pay a reasonable price, therefore. Number two, a minor 18 years old or above may contract for life, health, and accident insurance, provided the insurance is taken on his life and the beneficiary appointed is the minor's estate or the minor's father, mother, husband, wife, child, brother, or sister. Number three, a contract is valid if entered into through a guardian or legal representative. Number four, a contract is valid where the minor misrepresented his age or convincingly led the other party to believe in his legal capacity. And number five, a contract is valid where a minor between 18 and 21 years of age voluntarily pays a sum of money or delivers a fungible thing in fulfillment of his obligation thereunder, and the obligee has spent or consumed it in good faith. Next is other special disqualifications may be provided by law. In addition to the incapacity declared in Article 1327, other special disqualifications may be presented by law. Number one, under the rules of court, the following are considered incompetence and may be placed under guardianship. Letter A, a person suffering the accessory penalty civil interdiction. Letter B, hospitalized lepers. Letter C, prodigals or spendthrifts. Letter D, deaf and dumb who are unable to read and write. And letter E, those who are of unsound mind even though they have lucid intervals. And letter F, those who by reason of age, disease, weak mind, and other similar causes cannot without outside aid take care of themselves and manage their property, becoming thereby an easy prey for deceit and exploitation. So, a contract entered into by any of the above is valid except where it is voidable by reason of incapacity under Articles 1327 and 1328, or of causes which vitiates consent, or when or where the incompetent has been placed under guardianship. Thus, a prodigal is presumed to have capacity to enter into a contract. So, insolvents until discharge. Letter B, married women in cases specified by law. Letter C, husband and wife with respect to sale of property to each other. And lastly, other persons specially disqualified by law. So Article 1339, failure to disclose facts when there is a duty to reveal them, as when the parties are bound by confidential relations, constitutes fraud. So fraud by concealment. So a neglect or failure to communicate or disclose that which a party to a contract knows and ought to communicate constitutes concealment. In this case, concealment is equivalent to misrepresentation or false representation. The injured party is entitled to resign or annul the contract, whether the failure to disclose the material facts or intentional or unintentional, as long as there is a duty to reveal them and the party is misled or deceived in entering into the contract. If the failure is unintentional, the basis for the action for annulment is not fraud but mistake or error, even if intentional, but there is no duty to make the disclosure. The parties are bound by their contract. So, for example, Peter and Paul are partners engaged in the real estate business. Here, the parties are bound by confidential relations. So, Paul learned that Sam was interested in buying a certain parcel of land owned by the partnership, even if for a high price, even if for a high price. So, without informing Sam, Paul was able to make Sam sell to him his share in the partnership. Then Paul sold the land at a big profit. So in this case, Paul is guilty for fraudulent concealment because he was under the duty to make disclosure of facts having a bearing on the value of the interests of Sam in the partnership which were not known to Sam. So if the sale was at the initiative of Sam and Paul is unintentionally failed to inform Sam of Peter's offer, the cause for annulment is mistake of error on the part of Sam. Next is Article 1340. The usual exaggerations in trade when the other party had an opportunity to know the facts are not in themselves fraudulent. So, usual exaggerations in trade. It is the natural tendency for the merchants and traders to resort to exaggerations in their attempt to make a sale at the highest price possible. When the person dealing with them had the opportunity to know the facts, the usual exaggerations in trade are not in themselves fraudulent. Remember, the law allows considerable latitude to sellers' statements or dealers' talk, and experience teaches that it is exceedingly risky to accept it at its face value. So customers are expected to know how to take care of their concerns and to rely on their own independent judgment. Any person who relies on said exaggerations does so and is at his own peril. So, in effect, the law does not consider such exaggerations, even if known as false by the party making them, as amounting to fraud that will affect the validity of the contract. So, to constitute fraud, the misrepresentation must be of a fact, past or present, and not a mere expression of an opinion. So dealer stock or trader stock are representations which do not appear on the face of the contract, and these do not bind either party. So some examples are expressions or advertisements like the cigarette that will give you utmost smoking pleasure, you like it, it likes you, and other samples are the refreshment of friendship. Do you want your child to get higher grades? Then buy this certain fountain pen and for and other examples. Next is Article 1341. A mere expression of an opinion does not signify fraud unless made by an expert and the other party has relied on the form of special knowledge. So, expression of opinion. To constitute fraud, the misrepresentation must refer to facts, not opinions. Ordinarily, a mere expression of an opinion does not signify fraud. In order that it may amount to fraud, the following requisites must be present. First, it must be made by an expert. Second, the other contracting party has relied on the expert's opinion. And third, the option turned out to be false or erroneous. So, for example, Paul is a farmer, found a ring. He does not know anything about precious stones. He sells the ring to Peter, honestly believing and telling Peter that it is a diamond ring. In this case, there is no fraud, even if it turned out that the ring is not diamond because his statement is merely an expression of an opinion. However, if Paul is an expert on precious stones and he sells the ring to Peter, saying, I believe that this is a diamond ring, and Peter know that Paul is an expert, relies on his special knowledge, the contract is voidable on the ground of fraud. Actually, Paul, being an expert, is making a misrepresentation of fact and he cannot escape liability by expressing it in the form of an option. Next is Article 1342. Misrepresentation by a third person does not vitiate consent unless such misrepresentation has created substantial mistake and the same is mutual. So, fraud by a third person. So, a third person has no connection with the contract. Consequently, a misrepresentation by him does not vitiate consent. So a party should not be made to suffer for the imprudence of another in believing the fraud of a third person. So the presumption is that both contracting parties are acting in good faith. However, if the misrepresentation has created substantial mistake and the same is mutual, that is, it affects both parties, and the contract may be annulled, but principally on the ground of mistake. If the misrepresentation has been employed by a third person in connivance with, or at least with knowledge of the party benefited by the fraud, it is deemed to have been exercised by such party upon the other contracting party. Furthermore, it should be remembered that force or intimidation employed by a third person on one of the parties makes a contract voidable. The reason is because the consent is vitiated just the same. So, for example, Paul bought the land of Peter for 2,000 pesos per square meter. The reasonable price of lands in the same vicinity is 2,500 pesos per square meter, but Peter sold it only for 2,000 per square meter because Sam had deceived him regarding its market value. In this case, the contract cannot be annulled unless it can be shown that Paul was a party to the fraud. Next is Article 1343. Misrepresentation made in good faith is not fraudulent but may constitute error. So effect on misrepresentation made in good faith. So if the misrepresentation is not intentional but made in good faith, it is considered a mere mistake or error. Fraud is definitely more serious than mistake. Hence, the party guilty of fraud is subject to greater liability. For example, Paul sold a ring to Peter. So Paul honestly believed that what sold to Peter was a diamond ring. It turned out that it was not a diamond ring. So the misrepresentation of Peter is a mere mistake, and the contract is voidable on the ground that on the ground and not on the ground of fraud. Next is Article 1344. In order that fraud may make a contract voidable, it should be serious and should not have been employed by both contracting parties. Incidental fraud only obliged the person employing it to pay damages. So, two kinds of fraud in the making of contract. So, Article 1344 distinguishes two kinds of fraud in making of a contract. So we have causal fraud and incidental fraud. So what do we mean by causal fraud? Causal fraud, which is a ground for annulment of a contract, although it may also give rise to action for damages, while incidental fraud, which only renders the party who employs it liable for damages because the fraud was not the principal inducement that led the other to give his consent. This kind of fraud must not be confused with the fraud in Articles 1170 and 1171, which refers to the occurring in the performance of a contract without affecting its validity. Both kinds of incidental fraud do not vitiate consent. Next is requisites of causal fraud. So in order that causal fraud may vitiate consent under the above article, the following are the requisites. First is it should be serious. Number two, it should not have been employed by both contracting parties. Number three, it should not have been known by the other contracting parties. And the soundness parties, the seriousness of the fraud is a question of fact depending on the circumstances. It does not mean that its influence on the other contracting party, but its importance. The requirement that fraud should be serious excludes slight and usual deviations from the truth. Such deviations are frequently present, unfortunately, in transactions, especially those taking place in fairs and markets. Furthermore, when fraud is employed by both parties, neither may ask for annulment, as the fraud or of one neutralizes that of the other. The contract is therefore considered valid. The rule in accordance with the principle that he who comes to court must come with clean hands. For example, Paul is sold to Peter a parcel of land. So Paul told Peter that there were no 3,000 coconut trees on the land, although he knew that there were only 1,000. So B, so Peter bought the land relying on the statement of Paul. So the fraud here is serious, and Peter can ask for the annulment of the contract. If there were only a difference of, say, 50 coconut days, the fraud may not be serious or important enough to make the contract voidable. But Peter has a right to deduct from the contract price the amount representing the value of the 50 coconut trees. Next is Article 1345. So this article is all about simulation of a contract, either absolute or relative. So absolute contract takes place when parties do not intend to be bound at all. However, relative contract happens when the parties conceal their true agreement. Next is Article 1346. An absolutely simulated or fictitious contract is void. A relative simulation, when it does not prejudice a third person, is not intended for any purpose contrary to law, morals, good customs, public order, or public policy, binds the parties to their real agreement. So, meaning of simulation of a contract. So, what do you mean by simulation of a contract? So, simulation of a contract is the act of deliberately deceiving others by feigning or pretending by agreement the appearance of a contract which is either non-existent or concealed. So next is kinds of simulation. So there are two kinds of simulation: absolute simulation and relative simulation. So when we talk about absolute simulation, it happens when the contract does not really exist and the parties do not intend to be bound at all. So absolutely simulated or fictitious contracts are inexistent or void. For example, Sam is indebted to Nico. Upon learning that Nico is going to enforce his credit, Sam pretended to sell his land to, let's say, Jason, his father-in-law. So Sam did not receive a single centavo for the transaction, and he continued in possession of the land as the contract was merely simulated or fictitious. There is no contract of sale in this case, as the parties do not intend to be bound at all. Next is relative simulation. So what is relative simulation? So it happens when the contract entered into by the parties is different from their true agreement. The parties are bound by the real agreement provided it does not prejudice a third person and is not intended for a purpose contrary to law, morals, good customs, public order, or public policy. For example, Sam and Nico entered into a contract of mortgage, but wanting to hide the mortgage, it was made to appear in the form of a deed of sale. Here, there are two acts involved. First, the ostensible or apparent act, and the concealment or hidden act or contract of mortgage. As far as Sam and Nico are concerned, the contract entered into between them is a contract of mortgage. As to third persons, the apparent contract, the contract of sale, is entered into. Consequently, if Nico is a mortgage or if Nico is a mortgagee, but is made to appear as the buyer, and Nico sells the land to to Jason, the latter will require ownership. Here, Sam and Nico are stopped or barred from claiming that the real agreement entered into by them is a contract of mortgage. Next is Article 1347. So in this article, it implies that all things which are not outside the commerce of men, including future things, may be the object of a contract. Furthermore, all things which are not intransmissible may also be the object of contracts. It should be emphasized that no contract may be entered into upon future inheritance except in cases expressly authorized by law. Uh, it likewise all services which are contrary to law, morals, good customs, public order, or public policy may likewise be the object of a contract. Now, according to Article 1355, except in cases specified by law, leasing or inadequacy of cause shall not invalidate a contract unless there has been fraud, mistake, or undue influence. So, what is leason? So, leason is any damage caused by the fact that the price is unjust or inadequate. It is the injury suffered in consequence of inequality of situation by one party who does not receive the full equivalent for what he gives in in a commutative contract like sale. So effect of lesion or inadequacy of cost. So we have a general rule and we have certain exceptions. So for our general rule, a lesion or inadequacy of cost does not of itself invalidate a contract. Uh, Additionally, a person who willingly enters into a contract will be held bound by its terms, though the exchange of benefits may seem to be inequitable or unfair to him. The law assumes that the parties themselves remain the best judges of how much their bargain is worth. Now, for our exceptions, reason will invalidate a contract when there has been fraud, mistake, or undue influence, and in cases specified by law. According to Article 1470, Gross inadequacy of price does not affect a contract of sale, except as it may indicate a defect in the consent or that parties really intended a donation for some other act or contract. For example, Paul sold to Peter his land worth 100,000 for only 80,000 pesos. This contract of sale is valid although the price is inadequate. The fact that the bargain is unequal because of the inadequacy of price when both parties are in position to form an independent judgment concerning the transaction is not sufficient ground for the conciliation of a contract. Profits or benefits gained through skillful bargaining are the basis of free compensation. However, if it is known that Peter induced Paul to sell the land through fraud, mistake, or undue influence, the contract may be annulled in court. Now, according to Article 1356, contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. However, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that a contract be provided in a certain way, that requirement is that requirement is absolute and indispensable. In such cases, the right of the party stated in the following article cannot be exercised. So, meaning of form of contract. So, the form of contract refers to the manner in which a contract is executed or manifested. So, the contract may be oral or in writing, or partly oral or partly in writing. It may be expressed when the parties expressly sort forth their intentions, or implied when their intentions may be inferred from their actions or conduct. If in writing, it may be public or in private installment. So, when contract considered in written form. Uh, it is generally recognized that to be in written form and in written contract, all its terms must be in writing. So, a contract partly in writing or partly oral is in legal effect an oral contract. Next is classification of contracts according to form. So, according to the form or method used in creating the contract, they are informal or common or simple contract and formal or solemn contract. So, what do we mean by informal or common or simple contract? It is which may be entered into in whatever form provided all the essential requisites for their validity are present. This refers only to consensual contracts, such as contract of sale. An informal contract may be oral or written, and in fact may even be implied from the conduct of the parties. However, when we talk about formal or solemn contract, it is which is required by law or for its efficacy to be in a certain specified form. So rules regarding form of contracts. So we have a general rule and we have certain exceptions. So for our general rule, contracts are binding and therefore enforceable reciprocally by the contracting parties, whatever may be in the form on which the contract has been entered into, provided all the three essential requisites, such as consent, object, and cost, for their validity are present. So a contract may be oral or written, so a contract may be oral or written. So a written contract may consist of a letter, memorandum, note, or other instrument without following any particular form or language, it being sufficient that the parties clearly express their intentions. For example, Paul left a note in the store of Peter, offering 1,000 pesos for a table Peter is selling. So the following day, Peter called Paul by phone, accepting the offer of Paul, who promised to pay the next day. So the note, the note and the oral acceptance constitutes a legal enforceable contract, and both Paul and Peter are fully bound. So for our exceptions, form is required by the following cases. First, when the law requires that a contract be in some form to be valid. When the law requires that a contract be in some form to be enforceable or proved in a certain way, or when the law requires that a contract be in some form or for the convenience of the parties or for the purpose of affecting third persons. So next is form for validity of contract. So there are rare cases when the law requires that a contract be in a certain form for the validity of the contract. So for example, donation of real property, donation of property, the value of which exceeds 5,000, sale of land through an agent, stipulation to pay interest, and a contract of partnership. So when we talk about donation of real property, it must be in public instrument. when we talk about donation of personal property, the value of which exceeds 5,000, it must be the donation acceptance must be in writing. And when we talk about sale of land through an agent, the authority of the agent must be in writing, otherwise the sale is void. And stipulation to pay interest, it must be in writing, otherwise no interest is due. And for contract of partnership, if immovables are contributed, it must be in a public instrument to which shall be attached a certain assigned inventory of the immovable property contributed. So, form of enforceability of a contract. So, in the cases of contracts covered by the statute of frauds, the law requires that they be in writing, subscribed by the party charged or by his agent. So if a contract is not in writing, the contract is valid, announcing all the essential elements. Uh, so all essential elements present, but it cannot be proved, and therefore it cannot be enforced by either party if the other refused to form the contract unless it is ratified by the latter. Next is Article 1357. If the law requires a document or other special form, or as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form. Once the contract has been perfected, this right may be exercised simultaneously with the action upon the contract. So, form for the convenience of the parties. So in certain cases, a certain form or a public instrument is required for the convenience of the parties in order that the contract may be registered in the proper registry to make effective, as against third persons, the right acquired under such contract. So non-compliance with the required form would not adversely affect the validity nor the enforceability of the contract between the parties themselves. Furthermore, as between the parties, the form is not indispensable since they are allowed by law to compel the other to observe the proper form, and its right may be exercised simultaneously with the action to enforce the contract. Consequently, it is essential, however, before a party may be compelled to execute the required form, and that the contract be both valid and enforceable. For example, Paul, let's say Paul donated real property to Peter in a private instrument. So the donation is void because a donation of real property is required to be in public instrument to be valid. Hence, Article 1357 does not apply. Now, according to Article 1358, the following must appear in public document. Number one, acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable property, sales of real property, or of an interest therein are governed by Articles 1403, number 2, and 1405. So number two, the cession, repudiation, or renunciation of hereditary rights or of those of the conjugal partnership of gains. And number three, the power to administer property or any other power to which has for its object an act reappearing or which would appear in public document or should prejudice a third person. And number four, a cession or actions or rights proceeding from contract reappearing in public document. And all other contracts where the amount involved exceeds 500 pesos must appear in writing, even a private one. But sales of goods, chattels, or things in action are governed by Articles 1403, number 2, and 1405. So, which must appear in a public document. So, contracts governed by this article are valid and enforceable, though not contained in a public document or instrument or in writing. So, public document is required only for the convenience and greater protection of the parties and to make the contract binding as against third persons. In other words, the law does not require accomplishment of certain acts or contracts in a public instrument or in order to validate the act or contract, but only to ensure its efficacy so that after the exercise of the act or contract has been admitted, the party bound may be ordered by the court in which the action or suit is filed to execute the document. For example, there are certain examples. So first is creation, etc. of your rights over immovable property. So a security first step, let's say Paul mortgages land to Peter. This mortgage must appear in a public document. In this, the extinguishment of the mortgage upon payment of the debt of Paul must likewise appear in a public document. Sales of real property or any interest therein are governed by the statutes of fraud. Next is the cession or renunciation of hereditary rights or those of conjugal partnership of gains. For example, Paul and Peter are the heirs of Linda. So their deceased, I mean Alex, the deceased father. So Paul, being financially stable, renounces his share in the inheritance. So this renunciation must appear in a public instrument. So next is power to administer a property. So let's say Paul is leaving for the United States to study for 2 years. Here he appoints Peter. He appoints Peter as an agent to manage his property. In this case, the authority of Peter to administer the property of Paul must appear in a public document. Next is cession of actions or rights. Let's say Paul mortgaged his land to Peter to secure the payment of a debt. So this mortgage appears in a public document. So the decision by Peter of his right as mortgagee to to Alex must also be in a public document. Now, according to Article 1359, where there having been a meeting of the minds of the parties to a contract, their true intention is not expressed in the instrument purporting to embody the agreement by reason of mistake, fraud, inequitable conduct, or accident of one of the parties may ask for the information of the instrument to the end that such true intention may be expressed. If mistake, fraud, inequitable conduct or accident has prevented a meeting of the minds of the parties, the proper remedy is not reformation of the instrument but annulment of the contract. So, meaning of reformation. So, when we talk about reformation, it is that remedy allowed by law by means of which a written instrument is amended for rectified so as to express or conform to the real agreement of or intention of the parties. When by reason of mistake, fraud, inequitable conduct, or accident, the instrument fails to express such agreement or intention. So, reason for reformation. So, equity orders the reformation of an instrument in order that intention of the contracting parties may be expressed. Furthermore, the courts do not attempt to make another contract for the parties. The rationale of the doctrine is that it would be unjust and inequitable to allow the enforcement of a written instrument which does not reflect or disclose the real meeting of the minds of the parties. The rigor of the legislative rule that the written instrument should be the final and inflexible criterion and measure of the rights and obligations of the contracting parties is thus tempered to forestall or the effects of or mistake, fraud, inequitable conduct, or accident. So we have certain requisites of reformation. So in order that information may be valid or may be availed for us, may be availed of as remedy, the following requisites must be present. So first is that there is a meeting of the minds of the parties to the contract. Second, the written instrument does not express the true agreement of intention of the parties. Number three, the failure to express the true intention is due to mistake, fraud, inequitable conduct, or accident. And four, the facts upon which relief by way of formation of the instrument is sought are put in issue by the pleadings. And lastly, five, there is clear and convincing evidence of the mistake, fraud, inequitable conduct, or accident. Affirmation is thus not available as a remedy where no writing exists, or when, where a writing exists, there is no showing of any defect or consent therein. Note that in reformation of contracts, what is reformed is not the contract itself, but the written instrument embodying the contract. Next is reformation distinguished from annulment. So when we talk about reformation, there has been a meeting of the minds of the parties. Hence, a contract exists, but the written instrument purporting to embody the contract does not express the true intention of the parties by reason of mistake, fraud, inequitable conduct, or accident. However, when we talk about annulment, there has been no meeting of the minds, and and the consent of one of the parties being vitiated by mistake, etc. For example, Paul sold his land to Peter. It was agreed that the sale will include all the improvements. However, The contract is assigned by the parties states that the land is being sold, excluding the improvements thereon. In this case, the remedy is reformation because there has been a meeting of the minds. If Paul was selling his land, excluding the improvements, of Peter was buying his land, including the improvements, then there has been no meeting of the minds, and the remedy, therefore, is annulment. Affirmation cannot be the remedy because either way, it would not make the instrument express the real intention of both parties. Next is Article 1360. So the principles of the general law on the reformation of instruments are hereby adopted insofar as they are not in conflict with the provisions of this code. So, principles of the general law on reformation. In case of conflict between the provisions of the new civil code and the principles of the general law on reformation, the former prevails. The latter will have only supplementary effect. Next is Article 1361. When a mutual mistake of the parties causes the failure of the instrument to disclose the real agreement, said instrument may be reformed. So mutual mistake as basis for reformation. So what do we mean by mutual mistake? So mutual mistake is mistake of fact that is common to both parties of the instrument, which causes the failure of the instrument to express their true intention. So to justify reformation under this article, the following requisites must occur. First, the mistake must be of fact. Number two, such mistake must be proved by clear and convincing evidence. Number three, the mistake must be mutual, that is, common to both parties to the instrument. And number four, the mistake must cause the failure of the instrument to express the true intention. So, if the mutual mistake is of law, the remedy is annulment. For example, let's say Paul and Peter entered into a contract whereby Paul sold to Peter his horse named Silver. So by mistake, the contract as written and signed by the parties states that the horse is golden. Here, the instrument may be reformed on the ground of mutual mistake. Next is Article 1362. So if one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. So, mistake on one side, fraud or inequitable conduct on the other. So, under Article 1362, the right to ask for reformation is granted only to the party who was mistaken in good faith. Here, the mistake is not mutual. Lastly is Article 1363. When one party was mistaken and the other knew or believed that the instrument did not state the real agreement but concealed the fact from the former, the instrument may be reformed. So, concealment of mistake by the other party. So, the remedy of reformation may be availed of the party who acted in good faith. The concealment, always remember, the concealment mistake by the other party constitutes fraud.